Chapter 2, Uses of Domicile, Section 25, General Remarks. Before entering upon a consideration of the general subject of domicile, its definition, nature, constitution, and change, and the ordinary evidence by which its change is shown, etc., it will be well to take a brief survey of the general field, or perhaps it would be more accurate to say the several fields of jurisprudence in which it is usually applied for the determination of legal relations. To do this with any degree of detail would itself require a volume, and moreover such a discussion would more naturally and logically follow than precede the consideration of domicile per se. It is the object of the writer, however, here only to outline briefly the various uses to which in American and British jurisprudence the principle of domicile is practically applied, for the purpose, if possible, of approximately estimating the values as authorities of the several classes of cases hereafter to be cited in the body of this work. From this chapter therefore the continental authorities will be, in the main, omitted, and the several topics will be discussed as succinctly as possible, with references only to the leading cases and textbooks, to which the learned reader may refer for more elaborate discussion and fuller lists of authorities. Section 26. Domicile in public international law, national character. In general, the determination of the national character of a person, as subject, enemy or neutral, in time of war, depends upon his domicile, the general principle being that every person is to be considered as belonging to that country where he has his domicile, whatever may be his native or adopted country. This principle is usually applied in prize cases, in the determination of which, however, peculiar considerations prevail. The object of prize capture in war is to cripple the resources of the enemy, and thus indirectly abridge fighting by depriving him of the sources of his wealth and the means of supplying himself with the sinews of war. To attain this object, not only is the property of every person domiciled within the territory of the enemy held liable to capture, but also the products of the hostile soil and all interests and property in or connected with houses of trade established within the hostile territory, no matter to whom they may belong, whether friend, enemy, or neutral. Cases of this description are usually decided in the courts of the belligerents themselves, and at times and under circumstances which preclude the fullest investigation of all the facts bearing upon the ownership of the thing captured, and particularly of the facts bearing upon the animus of the claimant. For all these reasons, and because, moreover, there are great temptations, and great possibilities also, for the commission of frauds by claimants, prize courts have leaned strongly in favor of captors, and principles have been applied by them which do not prevail in other classes of cases. The development of the law of prize as it has been applied by the British and American courts is due mainly to the learned and luminous judgments of Lord Stowell at the close of the last and the beginning of the present century, and the leaning of the mind of that great jurist was, as has been pointed out by high authority, strongly in favor of captors. As a single instance may be given his remarks, in the Harmony, upon the subject of length of residence as indicative of domicile, in which he propounds doctrine wholly at variance with the views of almost all of the courts and writers who have spoken on the subject of time in its relation to domicile considered with reference to general purposes. From these and other considerations it is apparent that cases of national character in time of war should be used with the greatest caution upon the general subject of domicile. In this country the decisions of Lord Stowell have usually been followed, although not entirely without protest in some particulars by such jurists as Marshall and Story, but the Supreme Court of the United States in its latest decisions seems inclined to put the question of national character upon the broad ground of domicile, and for the ascertainment of domicile, to apply as far as possible the same principles and tests in cases of this description as in other cases. Section 27. Id. Naturalization. The Act of Congress regulating naturalization requires as a condition precedent to admission to citizenship 5 years residence in the United States and 1 year's residence in the state or territory in which application is made, and the residence required by the Act is domicile. Conversely, It has been declared by high authority that an American citizen cannot throw off his allegiance without a bona fide change of domicile. In questions of international citizenship, therefore, domicile plays an important part. Section 28. Domicile in private international and municipal law. In British jurisprudence, domicile finds its main application within the field of what is commonly known as private international law or the conflict of laws, that is to say, it is principally used for the purpose of ascertaining which of several conflicting territorial laws is applicable to the determination of certain legal questions arising between individuals. In American jurisprudence, domicile is similarly applied, but it is also very extensively used for the determination of the rights and duties of individuals under the municipal law, and particularly for the ascertainment of the place where such rights may be enjoyed and such duties must be performed. It is apparent that in the first class of cases, namely, those involving private international law, questions of national or quasi-national domicile can alone arise, while in the second class the question may be one of either national, quasi-national, or municipal domicile, although in point of fact, in cases of this character, municipal domicile most frequently comes under discussion. In continental practice, as we have seen, after the failure of the principle of national descent, domicile became, as it had been to a limited degree under the Roman law, the basis of the application of personal laws, or, as they were for a long time and to some extent are even now technically known, personal statutes. And this continued to be the almost universally received doctrine, at least until the adoption of the Code Napoleon, although there were many and grave disputes in its application. How far that system of legislation wrought a change in this respect is a matter which has caused some dispute, and cannot be considered as definitely settled. But during the past few decades there has been a growing disposition among continental jurists, which has also found expression to some extent in positive legislation, to replace domicile as the basis of personal laws by political nationality. But here again exist differences of opinion as to the extent and manner of the application of the new doctrine, and at the present day continental views upon the subject of private international law may be said to be in a very unsettled and unsatisfactory state, from which probably the only definite relief will be by some concerted action among the principal civilized nations, by treaty or otherwise. To state even briefly the views propounded by the leading jurists, or applied by courts upon the continent, would require more space than can be here devoted, and would indeed be beside the immediate purpose of this chapter. It seems best, therefore, to confine the discussion in the domain of private international law exclusively, or nearly so, to the doctrine laid down by the British and American authorities. Section 29. Status. It may be laid down that the status, or, as it is sometimes called, civil status, in contradistinction to political status, of a person depends largely, although not universally, upon domicile. The older jurists, whose opinions are fully collected by Story and Berg, maintained, with few exceptions, the principle of the ubiquity of status conferred by the lex domicili with little qualification. Lord Westbury, in Udney v. Udney, thus states the doctrine broadly: the civil status is governed by one single principle, namely, that of domicile, which is the criterion established by law for the purpose of determining civil status. For it is on this basis that the personal rights of the party, that is to say, the law which determines his majority and minority, his marriage, succession, testacy, or intestacy, must depend. Gray, C. J., in the late Massachusetts case of Ross v. Ross, speaking with special reference to capacity to inherit, says, "It is a general principle that the status, or condition of a person, the relation in which he stands to another person, and by which he is qualified or made capable to take certain rights in that other's property, is fixed by the law of the domicile, and that this status and capacity are to be recognized and upheld in every other state, so far as they are not inconsistent with its own laws and policy." But great difficulty in the discussion of this subject has arisen by reason of the loose and varying use of the term status, and the want of any clear definition of what is meant by it. Savinio understood it to mean capacity to have rights and to act, and this undoubtedly was the sense in which it was understood by the older jurists. In Neboyet v. Neboyet, Brett, L. J., gives this definition: The status of an individual, used as a legal term, means the legal position of the individual in or with regard to the rest of a community. But whatever may be the definition of the term, or whatever rules applicable to status in general may be looked upon as having received general acceptance, there are certain prominent states or conditions of persons, which have been treated of by writers and considered by the courts, and these it will be well to examine separately, with a view to ascertain how far they are affected by domicile. Section 30. Legitimacy and legitimation. Beginning with the advent of the person into the world, legitimacy, from birth, does not, at least immediately, depend upon domicile. A child born anywhere in lawful wedlock will be everywhere else considered legitimate. The lawfulness of the marriage must however be understood, with the qualification that it is such as is generally recognized among Christian nations as lawful, e.g., not polygamous or incestuous. Whether the child is born in or out of wedlock is a matter of proof with which domicile is not concerned. But with respect to the legitimation of one who is born illegitimate, whether by subsequent marriage or by an act of sovereign power, domicile is of vast importance. In a case of legitimation per subsequens matrimonium, it is possible to imagine 9 different sets of laws competing, namely, those of the places of conception, birth, and marriage, and those of the several domiciles of both father and mother at the periods of the occurrences named. In answering the question, by what law is the case to be determined, the period of conception has by common consent of jurists been entirely thrown out of consideration, and so has substantially the place of marriage. In favor of lex domicili of the mother plausible reasons may be urged, inasmuch as her domicile at the time of the birth of her illegitimate child becomes his domicile of origin, and subsequently any change in her domicile is followed by a corresponding change in his, and this view has been maintained by some. Nevertheless, modern jurists generally have eliminated the lex domicilii of the mother from the competition. There yet remain the lex loci of the birth, and the lex domicilii of the father at the time of the birth and of the marriage. Few contend for the place of birth, and practically the discussion among the modern jurists and in the British courts has been narrowed down to the lex domicilii of the father at the time of birth and at the time of marriage. Upon the continent the current of opinion is strongly in favour of the latter, while in Great Britain the current has been generally the other way, although there have not been wanting judicial expressions in favour of his domicile at the date of the marriage. Thus in Aikman v. Aikman, the whole point of inquiry, both in the Scotch Court of Session and in the House of Lords, was the domicile of the father at the time of the marriage. This was also the case in Monroe v. Monroe, where Lord Brougham said, with the exception of the learned Lord President, all the judges of the court below held that the subsequent marriage of the parents would legitimate the issue before marriage, provided the parties were domiciled at the time of the marriage in a country the law of which recognizes legitimation per subsequens matrimonium. And his lordship apparently adopted this view. It is to be noted, however, that in these cases the domicile of the father was held to be Scotch both at the time of the birth and of the marriage, so that the question between the two domiciles did not actually arise. But, on the other hand, in rewrites trusts, where the question was distinctly before the court, the father, who was at the time of the birth of the child domiciled in England, having before marriage changed his domicile to France, would, v.c., held that the capacity of the child for legitimation was to be determined by the law of the former domicile, and consequently held the child not to have been legitimated, and subsequently, in Udney v. Udney, the same judge, then Lord Chancellor Hatherley, declared that he saw no reason to retract that opinion. The same position was taken by Stewart, v.c., in Goodman v. Goodman, and by the majority of the Court of Appeal in the very late case of re Goodman S. Trusts. Dicey, while laying this down as the general rule, and holding that the child of an English father would not acquire capacity for legitimation by the subsequent change of his father's domicile, does not consider the converse settled, namely, that the child of a Scotch father would not be rendered incapable of legitimation by the father becoming domiciled in England. Phillimore and Foote appear to consider the rule settled in favour of the domicile of the father at the time of the birth of the child. Westlake, however, holds the result of the cases to be that legitimation per subsequens matrimonium will be recognised in England only when it is permitted by the lex domicili of the father, both at the time of the birth and at the time of the marriage. Certainly this is the only theory upon which the conflicting judicial expressions can be reconciled, but that such result will finally be reached by judicial decision appears doubtful. That it should be reached, more than doubtful. With respect to legitimation by act of sovereign power, in the Roman law, per scriptum principis, in ours, usually by act of legislation, somewhat different principles may possibly be applicable. A child legitimated by authority of the state in which he and his father are domiciled, should undoubtedly be held legitimate everywhere. Domicile is doubtless the basis of authority to confer such legitimation, unless we adopt the recent continental theory of political nationality. It is, however, possible that the domicile of the parent would not be so closely adhered to as in cases of legitimation per subsequens matrimonium, but that some effect, at least, may be given to the domicile of the child, if it be different from that of the parent. Section 31. Legal effects of legitimation. With respect to the legal effects of legitimation per subsequens matrimonium, it has been settled by Birtwistle v. Vardil in the House of Lords that a person so legitimated cannot inherit land in England. This was held, however, not because the status of legitimation so conferred by foreign law would not be recognized in England, but because, by virtue of the positive law of that country, and particularly of the Statute of Merton, land can descend only to those born in lawful matrimony. This decision has been followed in this country, and the converse has also been held in England, namely, that no person can inherit land the situate from a person so legitimated, except his own lawful issue. The question has been raised in England whether persons legitimated in this manner satisfy the definition of the word children used in the Statute of Distributions relating to personal property. The negative was held by Judicial, M.R., in re Goodman's Trusts, but his decision was reversed on appeal. It is, indeed, noticeable that there has been a disposition on the part of some lawyers in that country to restrain as far as possible the legal effects of legitimation under foreign law, rather, however, on technical grounds of construction than otherwise. Nevertheless, the decided cases fully recognize the existence of such status when it properly arises under the lex domicilii. In this country, where legitimation per subsequens matrimonium is so largely allowed, an opposite tendency is to be expected. The legal effects of legitimation by act of sovereign power are similar to those of legitimation per subsequens matrimonium. Thus, in the Louisiana case, where the Statute of Merton was never in force, it was held that a child legitimated by an act of the territorial legislature of Arkansas, where he and his putative father were domiciled, might inherit land situate in Louisiana. Section 32. Adoption. The validity of an act of adoption, and the legal status of parent and child resulting therefrom, depend upon the lex domicilii of the parties to it at the time it occurs. This was fully demonstrated in the late Massachusetts case of Ross v. Ross, in which Gray, C.J., reviewed at length the leading cases of personal status. It was there decided also that a child adopted in accordance with the law of their common domicile could take by inheritance from his adopted fatherland situate in Massachusetts. The contrary was held in an Illinois case, but in this, as in other instances, questions relating to the title to land are to be governed by the lex loci recit. Section 33. Paternal power. Continental jurists contend strongly for the regulation of paternal power according to the lex domicilii. But so far as this extends to the power of the parent over the person of the child, it is not admitted in our jurisprudence. Our courts constantly interfere to regulate the custody of children, and will allow a foreign parent no greater privilege in this respect than one domiciled within the territory of the court exercising jurisdiction. The lex domicilii is allowed in this country and in England no influence upon the relation of the parent to the immovable property of his child. This is governed exclusively by the lex loci recita. But the rights of the parent with respect to the movable property of his child are probably to be considered in our law as subject to the lex domicilii. This is the view indicated by a decision of Shadwell v.C., and it has been, at least tentatively, adopted by the text writers who have considered the matter. The question, however, still remains open. Section 34. Guardianship. There is no doubt that primarily the appointment of the guardian of a minor belongs to the court, or other proper authority, at the domicile of the minor. This is especially true with respect to the jurisdiction of the various courts or other appointing authorities within the same state. Continental writers with great unanimity contend for the recognition everywhere of the rights and powers of the domiciliary guardian with respect to both the person and the movable property of the ward, differing, however, in their views with respect to his immovable property. But this doctrine has not obtained in England or in this country. In Johnston v. Beattie, the House of Lords settled it that a foreign guardian has virtute officii no authority over an infant in England. The Court of Chancery, therefore, may, in its discretion, appoint a different guardian, and may interfere to prevent the removal of the ward by the domiciliary guardian. Of the American doctrine, Story says, in the states acting under the jurisprudence of the common law, the rights and powers of guardians are considered as strictly local, and not as entitling them to exercise any authority over the person or personal property of their wards in other states. Nevertheless, the domiciliary appointment is of considerable importance, and will be recognized by the courts of other jurisdictions in this country and in England, in their discretion, to the extent of handing over the ward to the domiciliary guardian for removal, or of requiring the local guardian to carry out with respect to the ward the directions of the domiciliary court or guardian. But this is a matter purely of discretion, which will be exercised in accordance with what the court conceives to be the best interests of the ward. With respect to the movables, Story lays down the following as the fully recognized doctrine both in England and in America, namely, no foreign guardian can virtute officii exercise any rights or power or functions over the movable property of his ward which is situated in a different state or country from that in which he has obtained his letters of guardianship, but he must obtain new letters of guardianship from the local tribunals authorized to grant the same, before he can exercise any rights, powers, or functions over the same. But here again the domiciliary appointment becomes important both with respect to the grant of local guardianship and because it is the constant practice of our courts, regulated in many states by statute, to direct the payment, upon proper conditions, to the domiciliary guardian of the proceeds of property, real and personal, in the hands of ancillary local guardians. Perhaps the whole matter may be thus summed up, namely, that the domiciliary guardian has virtute officii no authority beyond the territorial limits of the state or country appointing him, but that he will usually be everywhere recognized as possessing superior rights upon properly satisfying the local tribunal that such a right will be exercised for the best interests, personal and pecuniary, of the ward. Section 35. Minority and Majority. It has been frequently laid down that the question of the majority or minority of a person is to be determined by the law of his domicile. This is particularly true of the writings of the older continental jurists. But such a rule cannot be said now to prevail anywhere, even upon the continent, without much qualification. As to the capacity, with respect to age, of a person to enter into a valid contract, other than the contract of marriage, the law does not appear to be entirely settled in England. In the early case of Mayle v. Roberts, Lord Eldon declared that questions of this character are to be decided according to the law of the country where the contract arises. But in several late cases there are dicta broadly in favor of the lex domicilii. In this country there is a decision of the New York Supreme Court in favor of the lex loci contractis, and the opinions of the majority of the best text writers in both countries are the same way, as also is the analogy to be drawn from the American cases upon the capacity of married women. In the celebrated case of Saul v. his creditors, which has been much criticized and much misunderstood, Porter, J., used language which when rightly interpreted amounts to this, namely, that, when the defense of infancy is set up to a contract, the Louisiana courts will apply either the lex domicilii or the lex loci contractis, as the one or the other will the more tend to support the validity of the contract. And this is substantially the same rule as was subsequently enacted in both the Prussian and the Austrian codes. The same principle was applied by Lord Romilly in re Hellman's will in fixing the time for the payment of a legacy. Dicey lays it down that the capacity of any person for the alienation of movables depends, so far as the question of infancy or majority is concerned, on the law of that person's domicile. Testamentary capacity and capacity for marriage will be hereafter considered. Section 36. Marriage. With regard to the formal requisites of a valid marriage, it is now generally agreed that the lex loci celebrationis furnishes the true test. At least it may be laid down as the general rule, that a marriage celebrated in accordance with the formalities required by that law will be considered in this respect valid everywhere, although it may be added that in some cases also the marriage will be held valid if celebrated in accordance with the formal requirements of the lex domicilii. But with respect to the capacity of the parties to a marriage there has been much discussion and diversity of opinion. Two principal theories have been held: 1. That matrimonial capacity is determined by the law of the place of solemnization. 2. That it is determined by the law of the domicile of the parties. To these Wharton 4 has added a third, which concerns mainly our own country, namely, that our national policy in this respect is to sustain matrimonial capacity in all cases of persons arrived at puberty and free from the impediments of prior ties. Upon this question the doctrine of the English cases is in a far from satisfactory condition. The earlier cases were supposed to have settled the rule upon the basis of the lex loci celebrationis, but the later cases have shaken this doctrine, and in view of the recent decision of the Court of Appeal in Sotomayor v. de Barros, the rule may at present be considered to be, that the lex domicilii of the parties is the test, and further, that where the domiciles of the parties are different, that of the man is to govern, notwithstanding that the lex domicilii of the woman pronounces her incapable of entering into the particular marriage. In this country it is different, for, although there are some conflicting decisions, it is pretty thoroughly settled that the law of the place of solemnization furnishes the rule. This is in accordance with the very decided opinion of Story. Of course, when we speak of a marriage being valid by a particular law, it must be understood that such law is applicable only insofar as it permits marriages which are not polygamous, or incestuous according to the generally received opinion in Christendom. Therefore, a polygamous marriage of Americans in Turkey would not, upon the theory of the applicability of the lex loci celebrationis, be recognized by the courts of this country as valid, nor would such a marriage in England of domiciled Turks be, upon the theory of the lex domicilii, recognized by the English courts as valid. In either case the marriage would be considered as contrary to good morals and the policy of the lex fori, and therefore would be deemed void. Section 37. Mutual property rights of husband and wife. The marriage being assumed to be valid, in the absence of any settlement or express contract, the mutual rights of the husband and the wife in immovable property belonging to either of them are of course determined by the lex loci recito under our jurisprudence, although many high authorities on the continent contend for a different rule. As to movable property, domicile plays an important part. The mutual rights of the parties in the movable property belonging to either of them at the time of the marriage are regulated by the law of the matrimonial domicile, which may be described as the domicile which is contemplated or intended by the parties at the time of the marriage. Usually, but not necessarily, this is the domicile of the husband at that time, but it may be the domicile of the wife, if the parties intend to dwell at the place of that domicile, or it may be at a third place, if the parties intend to dwell there. In the absence, however, of proof to the contrary, the domicile of the husband at the time of the marriage will be presumed to be the matrimonial domicile. As to property acquired by either of the parties after the marriage, there has been much difference of opinion. The continental jurists generally contend that the law of the matrimonial domicile governs throughout the existence of the marital relation, and applies not only to property owned by the spouses at the time of the marriage, but also to subsequent acquisitions. But with respect to the latter, the doctrine is now settled in this country that they are governed by law of the actual domicile. This was early declared to be the true rule by Story, and is now abundantly supported by the decided cases. In England the question is not settled by judicial decision, and the opinions of the text writers, when expressed at all, appear to be divided. Section 37a. Construction of marriage contracts. Domicile is also of some importance in the construction of marriage contracts. It is by no means controlling, however, and no definite rule upon the subject can be laid down, inasmuch as in the construction of such instruments, just as in the construction of other contracts, a variety of matters must be taken into consideration, and each case must to a large extent stand upon its own circumstances. Section 38. Capacity of married women to make valid contracts. As to capacity to make valid contracts, much that has been heretofore said with respect to nonage applies also to coverture. Continental authorities assume the personal law, that is, that of the domicile, or nationality according to the new theory, as decisive. In England the question is an open one, with recent dicta in favour of the same view. But on the other hand it may now be considered as settled in this country, that the capacity of a married woman to enter into a binding contract is to be determined by the lex loci contractis. This question was examined at length by Gray, C.J., in the recent Massachusetts case of Milliken v. Pratt, and the result indicated was reached after an elaborate review of the authorities. There are decisions to the same effect in other states. This view has also received the unqualified support of Story and Wharton. Section 39. Jurisdiction in divorce cases. It is undoubtedly competent for the sovereign power of any state or country to confer upon its tribunal such jurisdiction in matters of divorce as it deems proper, and a decree pronounced by a competent tribunal under authority so conferred would necessarily be held valid and binding within the territorial limits of the state or country whose tribunal it was. But what effect, if any, would elsewhere be given to such a decree, depends mainly upon whether the jurisdiction of the court pronouncing it has been conferred and exercised in accordance with the generally received principles of international law. The test, therefore, of the validity, as to jurisdiction, of a domestic divorce is anything which the law-making power chooses to enact, while the test, as to jurisdiction, of the validity of a foreign divorce is, according to the generally received view, the domicile of the parties. The place of the celebration of the marriage is immaterial, and so, according to almost all the authorities, is the place of the commission of the offence. In England there has been considerable confusion in the decisions and judicial expressions of opinion upon the question of jurisdiction, until the Statute of 20 and 21 Vict. c. 85, which went into operation in 1858. Divorces of incullo could be granted only by Act of Parliament. Since that time they have been grantable for certain causes by a special court created by that Act, and since become one of the divisions of the High Court of Justice. The jurisdiction of the court is, therefore, purely statutory, and was, until recently, generally understood, although the matter was not considered as settled, to depend upon the domicile of the parties. But in Neboyet v. Neboyet, which was decided by a divided court of appeal, it was held to depend upon residence somewhat short of domicile. This, however, is merely the result of the construction of the Act of Parliament conferring jurisdiction upon this particular court, and does not in the slightest degree affect the doctrine held by the English courts with respect to the international validity of foreign divorces. Indeed, the English courts have constantly refused to recognise as valid Scotch divorces pronounced upon jurisdictional facts similar to those upon which the English divorce court finds itself compelled by Act of Parliament to assume jurisdiction. With respect to foreign divorces, it was formerly supposed that a marriage celebrated in England could not be dissolved, except by Act of Parliament, and it was therefore held that the decree of a foreign court dissolving such marriage was void, even though the parties were, both at the time of the marriage and of the divorce proceedings, domiciled in the country of forum. But this doctrine has now been thoroughly overturned, and the test which will be applied by the British courts to the jurisdiction of a foreign tribunal pronouncing a decree in divorce is the domicile of the parties. This has recently been held in the House of Lords in a case in which the matrimonial domicile continued up to the time the proceedings were had, and in view of the strong dicta on the subject, there is little doubt that the same doctrine will be held in cases where the matrimonial domicile has been changed, or, in other words, the test which will be applied is the domicile of the parties at the time of the commencement of the proceedings. In this country the decisions on the subject of divorce jurisdiction are very numerous and very conflicting, but the one principle which may above all others be extracted from them is that jurisdiction depends upon domicile. But what domicile? In the first place, the suit need not be brought at the place of the matrimonial domicile. If there has been a bona fide change of domicile to another state, the courts of that state will have jurisdiction. Again, it has been held in some of the states that the proceedings must be had at the place of the domicile of the parties existing at the time the cause of divorce arose. But the weight of authority is now against this position. It may therefore be laid down that jurisdiction depends upon domicile existing at the time the proceedings are begun. But whose domicile is to govern? We shall see hereafter that for all purposes other than divorce the domicile of the wife follows that of the husband. But if the husband deserts his wife and establishes his domicile in another state, it would be contrary to the dictates of natural justice and would only assist him in the perpetration of a wrong, either to deprive her of her remedy entirely or to compel her to follow him from state to seek redress. It is therefore well and properly settled that the courts of the state in which the parties were domiciled at the time of the desertion will entertain her suit and give her redress. But then arises the question, is this an exception to the rule that jurisdiction depends upon domicile, or to the rule that the wife's domicile follows that of her husband? The authorities generally take the latter position, and hold that a wife entitled to a divorce may for the purposes of divorce have a domicile of her own. And further it is held that under similar circumstances a wife may, quitting the place of the common domicile, go into another state and establish there an entirely new domicile for the purposes of divorce. Questionable as this doctrine may be upon general principles, and out of consonance as it certainly is with the principles of international law, as understood in other countries, it has the support of a number of decided cases in this country. There are many other positions and distinctions declared in the decided cases both of this country and England, but enough has been said to show the important part which is played by domicile in the law of marriage and divorce. Section 40. Relation of domicile to assignments of movables. Mobilia sequentia personam, or, as it was sometimes strongly expressed, mobilia ossibus inherent, was admitted by the older authorities as a maxim of very wide application, and hence, upon the assumption that movables could have no situs, they were considered as subject in almost all respects to the lex domicilii of their owner. But in modern practice so many exceptions have been admitted to this principle as to almost entirely destroy its force. As a rule, it will be impossible in this sketch to enter into any detailed account of these exceptions. We must content ourselves with a brief statement of a few of the most important principles upon the general subject of the assignment of movables. With respect to the assignment of particular corporeal chattels as distinguished from the general mass of the movable property of the owner, the tendency of modern theory and practice has been to recognize the lex loci recito as the applicatory law. And this may be said to be the now generally received view in England and in this country, both among the text writers and in the decided cases. It is true that Story, largely upon the authority of the older continental writers and the dictum of Lord Loughborough in Sill v. Werswick, in general leans strongly towards the application of the lex domicilii, although he admits that in many cases the law of the situs would be equally applicable, and in some cases entitled to superior respect. Assignments of debts are in general, but subject to many qualifications, governed by the lex domicilii of the creditor. This seems to be now settled in this country, but in England there are no decisions exactly in point. Section 41. General assignments, bankruptcy. But there are several kinds of assignments en masse of movables, which have been treated of by text writers and discussed in the decided cases, and with respect to which the principle of domicile has generally been acknowledged to be of considerable importance. They are, 1. Assignments by marriage, 2. By bankruptcy, and 3. By death, that is, a. Intestate succession and 6. Testamentary succession. The first has already been referred to. In England it is held that an assignment in bankruptcy under proceedings had at the place of the domicile of the bankrupt operates upon all of the movables of the bankrupt wherever found. This doctrine has been held as well in favour of foreign bankruptcies as in favour of those of English origin, and has been applied to the extent both of defeating the attempt of the creditors of foreign bankrupts to obtain preference out of movable assets in England, and of compelling English creditors of an English bankrupt to make restitution of funds received by them in payment of their debts out of the movable assets of such bankrupt in foreign countries, an exception to the latter application being made in favor of creditors who have obtained the payment of their debts by the decision of foreign courts. In this country the English rule was at first followed, even the high authority of Chancellor Kent supporting it. But now the doctrine is thoroughly settled the other way, that eminent jurist candidly admitting in his commentaries that it may now be considered as a part of the settled jurisprudence of this country, that personal property as against creditors has locality, and the lex loci recito prevails over the law of the domicile with regard to the rule of preference in the case of insolvent estates. This doctrine is applied not only to foreign bankruptcy proceedings, but also as a principle of interstate law to insolvency proceedings which are in invitum. But in the case of voluntary assignments for the benefit of creditors, there has been some conflict of opinion. Story holds that they will, if valid by the law of the domicile of the assignor, be allowed to prevail in other states, provided they do not violate some positive law or rule of public policy in the latter. But there has been an apparent tendency to test their validity rather by the lex loci contractus than by the lex domicilii, although the cases are not harmonious. Section 42. Intestate succession. With the third kind of general assignment of movables, namely, personal succession, whether testamentary or intestate, domicile has much to do. It is here that the maxim mobilia sequentia personam has its most general and effective application. It is a principle of international law, acknowledged in all civilized countries, except in those in which the doctrine of political nationality prevails, that in cases of intestacy the distribution of movables is to be governed by the law of the domicile of the deceased person existing at the time of his death. We have already seen when and how this rule was introduced into the jurisprudence of Great Britain and this country. Probably the only exception to the rule is in cases of exemptions and inheritance taxes under the laws of other states or countries, operating upon movables found within their territorial limits. Section 43. Testamentary succession. Validity of wills. In determining the validity of a testamentary disposition of movables, three principal points are to be observed, namely, 1. The personal capacity of the testator, 2. The formal execution of the testamentary instrument, and 3. The special validity of the particular disposition or provision in dispute. As regards the first point, it has been uniformly held that capacity to make a will is to be determined by the lex domicilii of the alleged testator. But as between domicile at the time of making the supposed will and domicile at the time of the death, in a case in which there has been a change of domicile, which is to govern story has apparently, although not certainly, declared in favor of the former, and Phillimore has followed him. But this view does not appear to be maintained by the weight of the authorities either in England or in this country, which hold the doctrine that capacity to make wills, as well as all other matters of testamentary validity, is to be determined by the law of the domicile existing at the time of the death of the supposed testator. As regards the formal execution and revocation of testamentary papers, continental jurists generally, applying the maxim locus regit actum, hold that a will is valid if executed according to the formal requirements of the place of execution. But this rule is said to be merely facultative and not imperative. Hence many hold that a will is valid if executed according to the formal requirements either of the place of execution or of the domicile of the testator. And this result has now been reached in Great Britain as to the wills of British subjects, by an Act of Parliament, Lord Kingsdown's Act. But in England, prior to the passage of that Act it was settled, and in this country, in the states in which there has been no positive enactment on the subject, it is now settled, that a will of movables in order to be valid must be executed in accordance with the formal requirements of the law of the last domicile of the testator. The same rule applies also to revocation. But even though a will be made by a person under no testamentary incapacity and be properly executed, its particular provisions will be held valid or invalid as they are in accordance or not with the law of the testator's last domicile. Section 44. Id. Construction of wills. The construction of a will of movables is, generally speaking, to be made in accordance with the lex domicilii of the testator. But whether it is the law of the domicile existing at the time of the execution of the will or of that existing at the time of the death of the testator, which is to be looked to, is neither clear on principle nor settled by the decided cases. Section 45. Probate and administration. The probate of wills of movables and the grant of letters testamentary and of administration belong primarily to the proper tribunal of the last domicile of the deceased person. Under our jurisprudence, Such letters proprio vigor confer no authority upon the executor or administrator beyond the territorial limits of the state or country in which they are granted, but in order to bring suits in, or to administer and take possession of, the movable property of the decedent in another state or country, it is necessary to obtain express authority from the proper tribunal of the latter state or country, either by a fresh probate or grant of letters or by entering such security as the local law may require. In granting ancillary probate or letters, however, the local tribunal will give great respect and weight to the acts of the domiciliary tribunal, and will as far as possible select as administrator the same person as has been entrusted with the administration by the latter. The administration of the local personal assets will always be carried on under the supervision and control of the Court of the Situs, but when all the expenses of administration and debts due creditors there are paid, the surplus will either be remitted to the place of the decedent's domicile or distributed by the Court of the Situs in accordance with the law of that domicile. There are numerous special points under this head which have been decided and discussed. As it is impossible in this sketch of the uses of domicile even to notice them all, the reader will have to refer for them to the special treatises and the decided cases. Section 46. Legacy and inheritance taxes. Closely connected with the foregoing, although it might properly also be noticed under a succeeding head, is the use of domicile for the purpose of determining the liability of the movable estate of a decedent to legacy duties and taxes upon its transmission. Probate and administration duties are of course determined by the laws of the state in which probate or administration is granted. They are the consideration paid for the grant and for the protection afforded by the state and the use of its legal machinery in the collection and administration of the estate, and with them domicile has nothing to do. But with respect to taxes upon the transmission of movable property, two principles may be adopted, namely, a. The state in which such property is found may tax it without regard to the domicile of its deceased owner, or b. Applying the maxim mobilia sequentia personam, the state or country within whose territorial limits the deceased person was last domiciled may lay a tax upon the whole of his movable property, without regard to its location at the time of his death. The first principle has been applied to some extent in this country, and the second has been applied both in Great Britain and in this country. It is thus held in England that legacy and succession duties are payable when, and only when, the deceased person was last domiciled within the United Kingdom, and this principle is applied without regard either to the location of the property or to the domicile of the legatees or distributees. By the law of Pennsylvania, collateral inheritance tax is payable to the state, a. upon all property within the state passing by will or intestate succession to strangers or collateral relations, and 6. upon all of the personal property, wherever situated and thus passing, of persons domiciled within the state. Other states have enacted similar laws, but this only need be referred to by way of illustration. Section 47. Jurisdiction. We have already seen that in the Roman law domicile furnished a very important, and indeed practically the most important, ground of jurisdiction. A person was subject to the laws of his domicile, and therefore bound to obey, and subject to the jurisdiction of, its magistrates. This is a very important principle, valid now as then, and cannot be kept too steadily in view in discussing questions of this kind. It received wide application on the continent upon, and to some extent before, the decadence of the feudal system, and is now extensively applied for the determination of questions of jurisdiction. Indeed, this is at present one of the chief uses of domicile under the French law. But under the English common law the sole basis of jurisdiction in personal actions was personal service upon the defendant within the kingdom, and this was applied alike to subjects and to foreigners, whether domiciled or transiently present, the place where the action was tried resting partly upon the will of the plaintiff and partly upon the distinction between local and transitory actions peculiar to the common law, and with which domicile had nothing whatever to do. In this country the common law rules have generally been applied, and jurisdiction, so far as regards the different local courts of the same state, has been made to depend mainly upon the fact of service of process upon the defendant. This is not universally true, however, for in Louisiana, following the civil law rule, and in some other states, by statutory enactments, jurisdiction is made to depend, to a certain extent at least, upon domicile. 3. But in the intestate questions of jurisdiction which are constantly arising in this country by reason of the large number of quasi-independent states of which our Union is composed, domicile becomes of great importance. This is brought into especial prominence in cases in which it is sought in one state to enforce, or otherwise give validity to, the judgments of the courts of other states. The Constitution of the United States declares that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. In pursuance of this authority, Congress, after providing for the mode of authentication, has declared that the said records and judicial proceedings, authenticated as aforesaid, shall have such faith and credit given to them in every court within the United States, as they have by law or usage in the courts of the state from which the said records are or shall be taken. In applying these provisions, the question first of all naturally arises, what is a judicial proceeding? And this is answered by the self-evident, as well as now thoroughly settled, doctrine that there can be no judicial proceeding without a court competent to act, that is to say, so far as concerns personal actions, possessing jurisdiction both over the parties and the subject matter of the controversy. Otherwise the proceeding is simply curam non judici, and does not fall within the meaning of the phrase. Hence it is settled by a long train of decisions, that when a judgment of a state court is sought to be enforced, or otherwise relied upon, in a court of another state or of the United States, it is entirely competent, notwithstanding the constitutional and statutory provisions above referred to inquire, even in contradiction of the record, into the jurisdiction of the court pronouncing the judgment, and if the requisite jurisdiction be found wanting, to treat the judgment as a nullity. Now, with respect to jurisdiction as to parties, it is no doubt generally true that a state may give to its courts jurisdiction over persons domiciled within its territorial limits, by any sort of service, actual or constructive, that it sees fit to adopt, and a judgment thereupon obtained would be considered valid and binding, not only in that state, but in all of the other states of the Union and in the federal courts. But such is not the rule with respect to persons domiciled elsewhere. For it is now settled that in order to confer upon the courts of one state jurisdiction in personal actions over persons domiciled in other states, there must be, a. personal service within the state of the court assuming to act, or, b. voluntary appearance either in person or by attorney, and a judgment of a state court without jurisdiction would be treated by the courts of the other states and of the United States as a nullity. And substantially the same doctrine has been applied to judgment obtained in courts of foreign countries. In England, the law with reference to the recognition and enforcement of the judgments of foreign tribunals is neither clear nor well settled. There is much apparent conflict in the decisions, and no rules as definite as those which are recognized in this country have been formulated. It is noteworthy, however, that the English courts themselves, under authority of an Act of Parliament, pronounce judgments upon extraterritorial service against persons domiciled out of the United Kingdom, which will not be recognized as binding in this country. Section 48. Judicial citizenship. A few special phases of jurisdiction have already been referred to. Several others will now be noticed. The Constitution of the United States gives to the United States courts jurisdiction of controversies. Between citizens of different states, and Congress, in distributing jurisdiction among the several federal courts, has assigned to the circuit courts original jurisdiction of cases where the suit is between a citizen of the state where it is brought and a citizen of another state. In applying these provisions it has been determined that a citizen of a particular state is one who is, 1. a citizen of the United States, native or naturalized, and, 2. domiciled in such state. It is true that in Shelton v. Tiffin, McLean, J., in delivering the opinion of the court, used language which seems to demand a further condition, namely, intention to become a citizen of the particular state. But the current of authority and opinion is entirely in favor of the rule as above stated. Moreover, the language of the learned judge was in this respect wholly obiter. inasmuch as no such intention was shown, yet a change of citizenship was held upon mere proof of a change of domicile from one state to another. Another instance of the dependence of jurisdiction upon domicile under the United States laws may be mentioned. Under the late bankruptcy law, jurisdiction in bankruptcy was given to the United States District Court in the district in which the debtor had carried on business or resided for the last 6 months, or the longest period thereof prior to the time of the filing of his petition, and this residence has been construed to be domicile in a case in which Lowell, Sir J., applied the most technical of all the principles of domicile, namely, reverter of domicile of origin. Section 49. Attachments against non-residents. Closely akin to the subject of jurisdiction is that of attachments against non-residents. Generally speaking, it may be said that the object of foreign or non-resident attachments is to grasp the property of those who cannot be reached in the ordinary way by personal actions. If, therefore, the position is correct, and how can it be gainsaid, that a state has the power to legislate with binding force with respect to all persons who are domiciled within its territorial limits, and thus to give its courts jurisdiction over such persons whether absent or present, it would seem to follow that logically foreign attachment proceedings should be applicable only to persons domiciled elsewhere. On the other hand, it is true that a state has, at least within certain bounds, the power to legislate with binding force with respect to all things found within its territorial limits, and therefore can, if it deems proper, authorize the laying of attachments upon any property there found, whether belonging to its own citizens or to strangers. Where, therefore, the legislature has clearly expressed its intention to grant such authority, theoretical views of jurisdiction have no application. But it happens that in the statutes of almost all the states of the Union respecting foreign attachments, the favorite legislative, but very indefinite, term residence is in some form used. This term, as we shall hereafter see, has been under many statutes construed to mean domicile, and if the question were an open one, there would seem to be, upon theory, plausible grounds for so construing it when used in the attachment laws, and practically a standard of at least reasonable definiteness would thus be furnished. But a contrary practice has prevailed in many, if indeed not in most, of the states, and residence, when used in this connection, is generally held to be something less than domicile, but approaching to and resembling it in some important particulars. What such residence is no one has yet succeeded in saying with any approach to definiteness, and the cases upon this branch of the law are in a most distressing state of confusion and conflict. It is true that the authorities upon the general subject of domicile are frequently used in cases of attachment, and the converse is also true. But it is apparent that great caution must be observed in using the cases of attachment as authorities upon the general subject of domicile. Still they are frequently useful as illustrating principles which are applicable to both classes of cases. For such purpose they will be hereafter cited in the body of this treatise. In some of the states, however, jurisdiction in foreign attachment proceedings is apparently placed upon the basis of domicile. This is notably so in Pennsylvania. Section 50. Limitation of actions. There is another use sometimes made of domicile which may be considered as having some bearing upon the relation of domicile to jurisdiction, namely, in the construction of the provision contained in the statutes of some of the states to the effect that the running of the statute in favor of the defendant shall be suspended for the time during which he is absent from and resides out of the state. And in some of the states, principally Massachusetts, such absence from and residence out of the state has been dealt with as a question of domicile. The theory apparently being that so long as the defendant remains domiciled in the state he remains subject to the jurisdiction of its courts, and that therefore an action can be commenced against him even in his absence. But the Massachusetts view cannot be said to be by any means the prevailing one. In the most of the states possessing similar statutory provisions, residence out of the state not amounting to a change of domicile being considered sufficient. But here, as in the case of foreign attachments, by reason of the extreme indefiniteness of the term residence, when not measured and defined by the rules applicable to domicile, great difficulty arises in obtaining any standard of decision which will not be found to be greatly varying and inconstant. Section 51. Taxation. We have seen that under the Roman law, at least during the imperial period, The chief application of domicile was to the determination of liability to municipal burdens, and this application has survived to our day. It has become in American jurisprudence a most useful principle for the ascertainment of the liability of individuals to personal taxes and taxes upon their personal property. Taxes upon immovable property can be assessed only at the place of its location, but movables, upon the principle of the maxim mobilia sequentia personam, are taxable at the place of the domicile of their owner, although there is a distinction in this respect between tangible and intangible personal property. The former may be taxed either by the state in which the owner has his domicile, or by that in which they have their actual situs, while the latter, including debts of all kinds whether or not secured by mortgage upon real estate situate in another state, is taxable only at the domicile of the owner. As to purely personal taxes, such as poll taxes, it is settled that they can be assessed only where the person is domiciled. The above principles have been stated with special reference to the interstate law of taxation, but they are equally applicable to intermunicipal conflicts unless modified by statute. A state having the power to tax a person may fix the particular place within its limits at which he shall be taxed by whatever standard it chooses to adopt. This has been done in most of the states by providing that persons shall be taxed in the municipal divisions of which they are residents or inhabitants, and these words have with great uniformity been construed to have reference to domicile in its technical sense. An attempt was made by the Supreme Court of Massachusetts in Briggs v. Rochester to ignore this generally received construction, but that case was subsequently overruled by the same court in Borland v. Boston, where an elaborate opinion was rendered, in which the subject was reviewed at great length, and the result reached that beyond doubt the word inhabitant as used in the Massachusetts statutes, when referring to liability to taxation, by an overwhelming preponderance of authority means one domiciled. This branch of the law has furnished a large number of cases in which the subject of domicile has been discussed and applied. Section 52. Liability to other public burdens. Domicile has been used in this country as the test of liability to other public burdens, among which two may be mentioned, namely, 1. Liability to militia service, and 2. Liability to jury service. The latter has, however, been usually discussed from the opposite standpoint, namely, that of eligibility. Section 53. Right to vote. In this country the qualifications for the exercise of the electoral franchise are fixed by the constitutions and laws of the several states. These qualifications vary somewhat in different states, although they are in most respects substantially the same everywhere. In most of the states citizenship of the United States is required, although in a number it is deemed sufficient if the person whose right is in question, being a foreigner by birth, has declared his intention of becoming a citizen of the United States. But the laws of all the states unite in requiring residence for a fixed period, which varies in different states, both in the state and in the particular election district, and residence, as so used, has, wherever the question has arisen, been uniformly construed to mean legal residence, or domicile. Section 54. Eligibility to office. Domicile is also frequently used in this country for the determination of other public rights of the citizen, one of which may be particularly mentioned, namely, eligibility to office, where such eligibility depends upon residence. Section 55. Settlement under the poor laws. Settlement or right to support under the poor laws depends, in England and in the various states of this country, upon various statutory provisions, the principal grounds, which are recognized in most of the poor law systems, of the right to such support in or by a particular poor district being, ownership of real estate, payment of taxes, and residence for a fixed period in such district. In England residence under the poor laws has never been considered as in any way connected with the subject of domicile. This is no doubt due to the fact that the principles of pauper settlements were substantially fixed before the introduction into English jurisprudence of either the term domicile or the definite notion signified by the term. In this country various statutory words, such as dwelling place, home, inhabitancy, and residence, have been used to fix the place of settlement, and these words in different states have been differently construed. In some states they have been held to mean, or treated as meaning, domicile, while in others a contrary view has prevailed. It is not proposed here to examine the decisions in the various states upon this subject. It is sufficient to notice early those of Maine and Massachusetts as representing the opposite tendencies. In the earlier cases decided by the Supreme Court of the former state, settlement was apparently put squarely upon the basis of domicile, but these cases have long since been overruled, and the position established by numerous decisions that residence, dwelling place, and home, as used in the pauper laws of that state, are not equivalent to, but mean something less than domicile. The principal difference noted, however, being that while a person cannot be without a domicile somewhere, he can be absolutely without a residence, dwelling place, or home. On the other hand, the Massachusetts courts have with great consistency construed inhabitancy, residence, etc., in the statutes relating to pauper settlements in the same sense as that in which they have construed the same and similar words in statutes relating to other subjects, and have with great uniformity held them to mean domicile in its technical sense. No apparent difficulty has arisen from the application of the Massachusetts doctrine, and it has the merit of furnishing a more certain and more generally understood standard of decision than any which can result from its rejection. In the present state of the decisions, however, it is unsafe to rely too far upon settlement cases as decisive of principles relating to even municipal domicile without at least inquiring into the general tenor of the decisions upon this branch of the law in the particular state in which they have been decided. But even when settlement cases cannot be relied upon strictly as authorities, they often furnish illustrations of principles which are equally applicable to domicile, and particularly to municipal domicile. For this purpose they will mainly be used in this treatise. Section 56. Homestead and other exemptions. One other use of domicile may be mentioned, namely, for the determination of the right of persons to homestead and other exemptions, out of their own property or that of deceased persons. All the states of the Union have passed laws allowing such exemptions, usually to their own citizens only, and in determining who are entitled to the statutory exemptions the principle of domicile has been extensively applied.